Common law relationships are on the rise, but many Canadians may not appreciate the need for a cohabitation agreement if that relationship goes south. Ron Shulman is the founder of Shulman Law Firm, and he joins me now. Good to see you again, Ron.
Nice to see you as well.
So I think in terms of people, deciding to live together, and maybe even in the priciest markets, they think, wow, look, someone to split the rent with. But there are no guarantees in life, and it might seem like a strange thing. We always talk about prenuptials, and that's a big step. You've agreed to get married, but you're just moving in together. How do you approach this agreement?
Right, and that's a big difference in marriage and common law. With marriages, there is a date, and there is something being changed, and people appreciate the difference in their legal status. With common law, what we find is that the majority of time, either people are entering into those relationships expecting it to be simpler. They may have been married before, and they're thinking, well, you know what? I don't want to be married. It's too serious. I will get into common law relationship. Or some enter into it gradually. They start living together. It's financial. Housing market is very expensive. And over time, they become common law. And they expect that, well, if we split up, well, we're like married. So it should be the same. Well, the reality is that both of those type of people, when they enter common law relationship, are quite surprised and shocked to learn that that's not how the law works.
Okay, so how does it work indeed? Because a lot of people do have that thing. Okay, suddenly, 2 years went by, very good. Now we're common law. This is the common idea of what it's all about, and we're just like we're married. But you say it's not. So what does it look like?
Well, the big difference is property division. And here's what truly shocks many of people who are coming to my office to talk to me when the relationship ends, is that common law spouses do not have any statutory property division regime in Ontario. None. For example, married couples have what we call an equalization regime. Equalization regime basically creates a formula to split assets, which were accumulated during the marriage. Common law spouses do not have that. In fact, if you look in the Family Law Act or any act, there is no mention of that. What they do have is they have what's commonly known as a trust claim. It's a complicated body of case law, and I'm not going to be overcomplicated here, but it talks about simplicity. It talks about fairness. So in the bottom line is a party who wants to make that claim after a common law relationship would have to go to court, prove his or her contributions to the assets, and then be able to establish what is fair to recover backwards. And that is truly complicated, expensive, time-consuming, and also proof-based. So not many people keep records of how much money they put into a house, or did they pay property taxes. Maybe one of the common law spouses was off work for a bit, and somebody else picked up the tab. So that's where it gets much more messier and complicated. And when a lawyer says that, it means more expensive to resolve.
Yeah, complicated, messy. That's a code for you're going to be paying a lot more for it. So this cohabitation agreement, at what point should people start thinking about it? I mean, maybe they move in together and neither of them is thinking, I'm not saying this is going to last forever, but we're moving in together right now. At what point do you decide, oh, this might be getting serious?
When the relationship gets serious, when two people decide that they're going to be living together, this is the time to think.
Right from the get-go, right?
Right from the get-go.
So what do these agreements look like then, and how much of a role does a lawyer need to play?
The agreements fundamentally discuss and create stability. And that's what they're all about. It's creating predictability and stability in the event that when the relationship dissolves. It creates a clear set of expectations. For example, if the house is going to be purchased, if there's going to be sharing of expenses, it will be joint bank accounts, or there will not be joint bank accounts. And what will happen to those joint assets? If one of the parties, for example, have a bad credit, and the house is registered in the common law spouse, what's going to happen with the contribution they put in? Do they have to prove the contribution? Like, all of those questions get ironed out. The usual recommendation which I give to my clients is, first of all, sit down and talk to your common law spouse. Talk about predictability, talk about stability, and talk about how would they see those assets being divided if they are accumulated. And then come see a lawyer.
How many conversations like this do you have? Because I can think about, I've been married for almost 20 years now, but we lived together before we got married. And at that point in our lives, neither of us had much money. So if someone said, why don't you have a cohabitation agreement and go see a lawyer, you'd be like, yeah, we're not going to do that, simply because it would cost us money.
Well, of course, and initially, and that's the reluctance with many people, is to enter into those agreements or talk about them. The other reluctance, obviously, is that it's not the most fun discussion to have before you're thinking about moving in together. But the flip side of it is predictability. And so instead of the negative aspect of the agreement, and what I advise my clients is instead of focusing on the negative part of it, is focusing on creating that stability and predictability. The predictability that married couples, to a great degree, enjoy by virtue of statute.
Luckily for us, it would have been a short meeting with the lawyer because they would have said, what are your assets? I would have said none. What are your assets? My wife would have said none, and that would have been the end of the discussion.
And that is quite true. Many people start with their relationship with no assets, but then they accumulate, and that's when it gets more complicated. If they don't do a cohab agreement at that point, then definitely before a purchase of a property or any significant assets, it needs to be considered.
Good tips indeed. Thanks for joining us again, Ron.
Thank you very much.
Ron Shulman is the founder of Shulman Law Firm.